E te manga o te whare, tēnā koe, Mr Chair, tēnā koutou. Mr Speaker, it's difficult to speak for just a short few minutes on some of the significant issues that exist in the justice system more broadly at the moment. My colleague has already talked about the shortfalls for police funding. We have significant issues in corrections. I want to talk a little bit about some of the issues that the Minister of Justice herself raised, because when we have a crime perpetrated against an individual or someone who, for whatever reason, may find themselves needing to access the court, access to justice issues become critical. They're a critical part of a well-functioning society, a well-functioning democracy, and being able to access that justice system, whether it's to prosecute a case, a civil case perhaps, or to defend yourself, if we don't have mechanisms in place that enable people, whatever their circumstances, to do that, then everything falls apart. And I've seen, Mr Chair, within the justice system, significant issues in that area. Now, access to legal aid is one way that we can make sure that we have an accessible justice system. The thresholds in New Zealand for accessing legal aid are incredibly difficult. You basically can't earn minimum wage and be eligible. Yes, it has shifted marginally for civil legal aid, but I'd have to say I imagine that the Minister's almost had her hand forced on that because of the increase we've seen in self-representation. That causes a number of issues, not only for individuals who often struggle with a complex legal system, but also it has issues for the courts and tends to slow down cases going through the courts. So that's a significant issue. And I want to give a graphic illustration of how thresholds to legal aid can really affect those who need to access our justice system. Protection orders. Most people in New Zealand would probably think that a protection order was free and accessible. But actually we have hundreds of cases of predominantly women who have tried to access legal aid in order to have a protection order, seek the assistance of a lawyer to have an urgent protection order issued, and have been denied legal aid for that purpose. Now, when you have an income test which could, for instance, assess the family home as deeming you ineligible for legal aid, that's obviously problematic when it may be a partner that you're seeking a protection order against, but you're income tested in that relationship. It should be, Mr Speaker, that either community law centres are funded to help issue protection orders, or we just make a legal aid application automatically approved if it's for a protection order. Something needs to be done in that area. But actually that leads me neatly, Mr Chair, to the issues in the family court. It just defies belief to me that the government would not want to review the massive reforms they implemented, given the huge issues that they are now manifesting. Not only do we have issues accessing protection orders, but actually I've had numerous cases now come before me where a protection order, which is meant to be for natural justice purposes, able to be challenged within a court within a set period of time, but where cases have not been heard before the court after 6 months after a protection order has been issued. And these are cases that involve children and have significant safety concerns attached to them. And access is one of the things that needs to be discussed in the family court, and they can't access it. It's a significant problem, one I've continually raised with the Minister, one that Principal Family Court Judge Lawrence Ryan acknowledged that there has been an astounding increase in without notice applications, and that is indicative of people trying to avoid some of the processes that have been established through reforms and get straight to the court so they can have a lawyer represent them. The reforms in many ways have failed. They must be reviewed urgently. Mr Chair, I want to speak briefly to community law centres. They've had static funding at $10.9 million for some time, since 2008. The Minister boasted there'd been an increase. There hasn't. In fact, all there is contingency funding if the special fund dips in order to bring them up to that static funding. They do huge work. On behalf of us as MPs too, I must add, they must be funded properly. I'd urge the banks as a starter to drop the take of the special fund that they're taking. It's ridiculous to claim 40% in costs and charges to administer the special fund. Those banks, and they know who they are, should be passing on.
Jackie Dean.
Thank you, Mr. Chair.